Good to be here this afternoon. I am a political candidate. My name is Bill Wohlsifer, and I am running for Attorney General. And I am the Libertarian Party candidate, and I'm not here for party politics, as our host just indicated. This is not a political rally. This is an educational event. And we were certainly just educated by Joselle, Annalise, Mariah, and Renee. I've met with them before. I've met with other Canna moms and fathers around the state. These four women are a little more vocal than some and maybe have a little more assistance or are able to get out a bit more, but they're not alone. There's a lot of people struggling in the same way they are. And that struggle needs to end, particularly because we're in this position for all the wrong reasons. And the comments that we heard from Renee about voting and choosing who you vote for is well stated. If you look to the Florida channel, if you receive it in your area, and I know people come from around the state and outside the state here, but you'll find videotapes of our legislature meeting in 2014 and prior. Watch the one where they debate HB 43 and SB 1030, which has turned out to be what's commonly called the Charlotte's Web bill, our SBD bill here in Florida. And you get an idea of some of the representatives who did their research, who maybe didn't know about the issues in the beginning, but went out and did the research and learned. And you'll see some others that didn't do that and didn't learn and have archaic preconceived notions of what it is they're actually debating. We see some debating, and as well as the rulemaking that's now taken place with regard to the CBD bill that's going to roll out, as if they were discussing how to handle a radioactive material. It's unbelievable. Cannabis is a grass, it's a weed. It's essentially harmless in the way you handle it. And the rulemaking and the thought process that's gone into the lawmaking shows just a lack of understanding of some of their parts. So do your research, please, on the candidates that you vote for if you are a Florida voter. I am a statewide candidate, and I am active in medicinal cannabis. I have been active for quite some time. My first public advocacy, let's say, was prior to my candidacy. In 2012, I wrote what has come to be known as the Kathy Jordan Medicinal Cannabis Act. I did not know Mrs. Jordan at the time, but just sat down voluntarily without pay and decided to write a bill for Florida's use at the legislative level as a citizen drafter, not as an attorney. No one asked me or paid me to do it, although I did affiliate with a number of organizations before it finally reached both chambers. And in doing so, I learned more about the subject matter than I had known in the beginning. I essentially started out, my wife, who's here, my wife Steffi had pointed out a 60 Minutes segment that a lot of us have seen, a lot of folks in this room have seen, and I saw how well things were going in Colorado for their patients. At that time, it was not recreational Colorado. And I said, well, we could do better in Florida. And I set out to contribute whatever I had to contribute in that respect. It came to be known as the Kathy Jordan Medicinal Cannabis Act. It was introduced by Senator Clemens in the Senate in 2013, by Representative Edwards in 2013 in the House. It was reintroduced in both chambers in 2014. That's a lead into what I'm going to talk about this afternoon, and that is Florida legislation. I know there's some speakers going to speak later about licensing and about the rule promulgation that's taking effect now for the bill that's going to roll out of the last session. I'm going to talk about the bills that passed and the bills that didn't pass. And the reason for that is I think we're going to see them again. Just because they didn't pass doesn't mean they're gone. We do have Amendment 2 is going to be on the ballot. We do have a medical necessity defense that you've heard the Canna moms talk about. We do have some attorneys in the state arguing for that affirmative defense, and we have some other attorneys with creative arguments as to why there should be a preemptive entitlement prior to a criminal violation that calls into play an affirmative defense to criminal violation. Those are all at play as well as Amendment 2, and I know everyone in this room probably knows very much about what I'm going to talk about and about Amendment 2. But for the sake of some who don't have that level of familiarity, I'll digress here and there. Amendment 2 is going to be on the ballot in November. It's a constitutional amendment. If it passes, it will be ingrained in Florida's Constitution for a long time, perhaps not engraved in stone, as we just have seen our state constitution being reversed by 4 judges, and yesterday by Judge Hinkle at the federal level with regard to same-sex marriage. So even where a citizen petition has reached the ballot and was voted in by candidates in 2008, that is still subject to court interpretation as time goes on. So I take what I refer to as an all-of-the-above approach. We have a CBD bill. It doesn't go far enough, but it's something. It will help a limited population for limited ailments. We have an Amendment 2 that I don't think goes far enough, but it can. It depends on who is in office when the rollout comes, when the implementation comes to turn that constitutional mandate into a law. The amendment itself doesn't contain much law. It allocates rule-making to the Department of Health and sets parameters that the department is to work within. We have seen this pattern many times in the past. Sometimes the rules that are made are outside those parameters, they go beyond it, or they don't meet it. And what happens then is we have the judicial branch comes into effect and interprets those rules, looks at the law, and the Attorney General's office comes into effect, the office that I'm running for, because one of the roles of the Attorney General, and there are many, one role is to draft Attorney General opinions. The Attorney General being a policymaker, not a lawmaker, largely is responsible for policy, but also issues these opinions. And these opinions are not binding on the courts, but they're very persuasive. What the law refers to as persuasive, not mandatory law. And we are going to have issues of first impression like we've never seen before in 2015. Because of the CBD bill, because Amendment 2 is very, very likely to pass. It requires your vote. I do caution here, we see polls that say it has 89, 88% approval. That's for medical marijuana. That's not for Amendment 2. The approval there is a little less. So don't rely on 90% of the voters coming out. Make sure you get yourself out there as well and everyone you know, and we move this forward. But again, it's important how it takes shape after it passes. And some of that shape will come from the Attorney General opinions where state officers, which will include our agencies, including the Department of Health, who's going to implement the law, the rules rather, and law enforcement, who turns to the Attorney General and asks for guidance on what does this mean? What do these new laws mean? How do we apply it? How do we interpret it? I get asked questions all the time that are tough questions because people have great creative minds and can look forward and realize a lot of things are left unanswered. The same thing with the same-sex marriage. That is going to be reversed, has been reversed, subject to appeal, and we'll have issues of first impression there because it's not going to end with same-sex marriages. The intrusion on our civil liberties and the unequal application of equal rights protection is all coming to play in 2015 through the next 4 years. Those are the laws I want to be involved in. Those are the opinions I want to be drafting. So there's a lot of, I won't say politics, but there's a lot of lawmaking here. And the representatives, you know, the word is represent. They represent your views, not theirs. And I point it out because sometimes I look at the laws that are coming down the pike, and I know those are not my views, or the people that I discuss them with. So I've got a PowerPoint. I can see it down there, so I'm looking down there because there's a monitor. And I'm going to move through it pretty quick to allow some time for questions. That was my scorecard for 2014. There were 3 bills, a U.S. bill at the federal level. That was HB 99, I believe, which was for to remove medical marijuana from the controlled substance list. That would also could be shaped. It was just an introduction. That could have been shaped into a medical marijuana bill or an industrial hemp bill. You got to keep in mind when these bills are introduced, they can take a very different look in the end. They don't even look like what they started out to be sometimes. And that's what happened to our CBD bill. In fact, that started out as a HB 843, which was really a hemp bill. It just allowed for a low-level THC strain of cannabis to be legal to help with intractable epilepsy. Those who suffer from it, it turned into a bill that has, it's highly restrictive. The rollout is going to be very restrictive, as most of us know. But we had 3 bills, that's one. Another was a recreational bill introduced by Senator Bullitt out of Miami-Dade County. That's a wonderful bill. That's a recreational marijuana bill. That was not a medicinal bill. Medicinal use is fine, but that was it was a recreational bill. I think fashioned out of the something that the state of Maine has looked at, full use for persons over 21. A move in the direction of ending the war on drugs, which is one of the reasons that a lot of the elected officials are afraid to use common sense because the war on drugs leads them from exercising that common sense. So those are two things we have to address. The other bill was the Kathy Jordan bill, which unlike the, let's say unlike CBD and unlike a possibility of the outcome of Amendment 2, is a fully integrated bill that does not involve one agency. It involves multiple state agencies. It involves anti-competition clauses. It allows for persons to participate in the industry, notwithstanding some prior criminal convictions with limitations, allows for homegrown, allows for various quantities. We're not so sure Amendment 2 allows for homegrown. Some people believe it does, and some think it does not. I would say that it's not clear, and it'll be made clear in 2015. I really think it's going to dominate the 2015 session for our legislators to roll out Amendment 2. So the Charlotte's Web bill I covered, there's the legislators that introduced it. There's the Kathy Jordan bill, which many folks, including myself, hope serves as the framework for Amendment 2 after it passes. Those two can act together. I want people to realize I have an all-above approach, and I think that is a workable approach. Same thing with the medical necessity defense. It's been around arguably since the common law, since the nation was born. 1776, and has been the law of our state since 1991. And there's certainly a legal precedent to substantiate that. So I'll just roll through this. I'm a little bit ahead of this PowerPoint. I'll just roll through for the sake of the visual aspect of it. Well, this is kind of interesting. The different bills have different definitions of what a dispensary is, what a treatment center is, what a physician's role is, and how the medicine reaches the patient. Under the constitutional amendment, we have the medical marijuana treatment centers. It appears that the contemplation there is for what's referred to as vertical integration. That is the cultivator, the processor, the transporter is all the same entity. The provider is the same entity. The dispensary is the same entity. That's vertical integration. The Republican-led legislature this year, and I'm not going to be partisan, they're Republican-led, found that was necessary for medical marijuana, but yet was not the preferred business model for craft breweries. There, they thought craft breweries should follow a vertical integration plan where the brewer, the transporter, and the distributor are different entities for the sake of consumer protection and anti-monopoly. Two different results there for two different products, one medicinal, one recreational. Charlotte's Web has dispensing organizations. I can't really read that monitor. And then the Kathy Jordan bill has medical cannabis farms and dispensing centers. I'm not going to guess what that says. I just can't see it. So we'll go forward. Don't know you want to read all that. You can find that information here and there. I mentioned before that there's a reason, and it's the wrong reason, why marijuana is illegal, and that was to outlaw hemp. No surprise there. I think most people know that. In 1937, an inventor came up with a device referred to as a decorticator, something like that. I can spell it. And what it was able to do, I can't say it, I can spell it. What it was able to do was to remove the inner core of the hemp stalk from the outer fibers that have the more productive use. And the production contemplated at that time, in addition to medicinal value, was to replace synthetics, cotton, wood, and it was predicted that it would actually revolutionize those three industries. And as a result of that, entities at the time, and I just won't even name them, we all know this history. As a result of that, they panicked and they said, we can't have this. We cannot have an industrial hemp industry right now. It'll hurt those other three industries as well as the banking industry as we know it, and we need to do something about that. And what they did is they demonized industrial hemp by relating it to reefer madness for marijuana use. So I suggest to everyone here today that hemp is not illegal because it's like marijuana. Marijuana is illegal because it's like hemp. This is the common sense argument that we need to overcome, that our representatives need to overcome. And we also need to see industrial hemp in this state. And we have a speaker who's going to speak about that after me, and I'm going to leave that to our next speaker. So we thank our legislators for Charlotte's Web. We thank them for the CBD bill. But also it's sort of a thanks, but no thanks. I'm concerned there that the cronyism is at play, that the requirement that a nursery be in business for 30 years in order to apply for a selective grant, and perhaps a random grant, we'll see when the rules are finally done, of the license to be one or not more than 5 of the centers that grow, cultivate, transfer, and dispense that product is, there's no precedent for it. There's just no precedent for a 30-year requirement in any industry that I'm aware of to be able to participate in that industry. Some of the other requirements are overreaching as well, in my opinion, and very concerned here, and I know those that are anxious for access are concerned that it doesn't look like in New Jersey, for example, where marijuana became legal, there's just nowhere to get it. And I think a lot of that, and I fear a lot of that is because there are people that are trying to grab a share of the market. They want a market position. They want that first mover advantage to the detriment of entrepreneurs and other smaller investors that cannot compete. So it's a concern. It's a concern that's going to be addressed by the 2015 legislature and by the cabinet and by the governor. And again, that's one of the reasons I ask you to look at my campaign, and I'll touch on where you can find that at the end, because I'm running for one of those cabinet positions, and perhaps the most important when it comes to shaping legislation over an item that's on the controlled substance list. It's a little interesting here. This is I highlighted this, not to play games with words, but it reads, I won't actually read it. You can't do that. And that's the law. That's passed. That's in there as a precursor to say this is why we need to have the registry. But I worry about the registry. I worry that some employers are going to look in there and not hire potential employees because they're using cannabis, which is still in violation of the federal law. The employer can attach whatever value they want to that. I worry that they may say the patient, rather the employee, has medical conditions that they don't want to employ. I worry about what just happened to my PowerPoint. Can I get assistance with that? Oh, here we go. Thank you. Okay, well, I'm going to go back in fairness because I don't want to play games with the language. I'm not going to go forward. I'm sorry. Well, okay, I'm not going to find that slide, and I'll just say that's the fear, and then the justification is so we have a registry. We know what happens with these registries. They become corrupt. They become penetrated. The content becomes known. I don't think it's a good idea. I'm afraid it's going to keep some folks from obtaining access that they otherwise need and would obtain. I know for sure some people don't want their name in there, and they're going to just wait for another law to come around. And that's okay, because it's coming. There's going to be more law. This here speaks about, from an agricultural perspective, the plant is a plant. It's an agricultural product when it's on the farm. At some point, it becomes a consumer product. Just like the potato becomes a potato chip, at some point it takes on a different nature for the sake of taxation, for the sake of whether it's a household remedy or a consumer good, whether it's an over-the-counter product, whether it's a pharmaceutical. Right now, we know that Charlotte's Web is not going to be considered that. That's a picture of me talking about what I referred to before. Is Tallahassee under the influence of big beer? We asked that question because when it comes to craft beer, we have one form of integration of marijuana and another. I have not found a good reason for that. That makes me suspicious. Health and freedom go together. I like that. I'm an attorney general candidate. I'm an advocate for medical marijuana. I'm an advocate for open competition, free markets, entrepreneurship. I think having open competition and free markets not only creates opportunities for individuals to compete and participate, but I think it brings more skills, knowledge, and creativity that otherwise would be closed out of the market. There's no greater minds than the minds that are thinking ahead and looking forward to implementing these laws. And I really want to do what we can to keep that an open market. And again, it's going to come, the devil's in the details, as they say. Once this passes, it's going to come in the next session. And I think these other bills will be introduced as well. Low-level THC is a product that Mr. Edmonds will talk about. I'll just mention here that under Section 893-0355, the Attorney General does have the authority to control what's on a controlled substance list. And I've pledged that on day one, I would remove low-level THC from Florida's controlled substance list so that plant access is available for medicine, so that we can have real compassionate use, which is homegrown. I have a hard time finding compassion in compassionate use termage when homegrown is not included. This is going to be expensive, and not everyone's going to be able to afford it, and insurance companies are not going to chip in. So that's hemp, and hemp is going to be a great industry as well. So look to the Attorney General candidates, look to the legislatures, look to Florida's future. I think I may have some, do I have some time for questions? Okay, a minute or two. I'll open the floor for questions at that point then.
Raise your hand if you have a question.
Yes, sir. Oh, I'm sorry, you want to call him?
Go ahead, sir.
I can only guess. Maybe it's an educated guess because I've watched pretty closely. I think Senator Bullitt, who had what it takes to introduce a recreational bill, will introduce it again. When you hear him defend it, he can certainly justify why we need such a bill. We learn that the war on drugs crosses racial lines. Our prisons are overcrowded. Creative people keep coming up with these bath salts and synthetic marijuanas. A lot of that can be stopped by regulating access. I'd like to think the Catholic Jordan Act will be reintroduced. It came back twice. I'd like to think it'll come back again. I'd like to think Amendment 2 will pass. I'm an all-above guy, as I said before. The affirmative defense of medical necessity is going to continue to be advanced, and I think that the preemptive use of medical necessity is going to continue to be advanced. So I think that it's an evolving law, and that one day we will have very good access in Florida.
Okay, we're going to take one more, and then we'll have more questions afterwards. You can grab Bill when he comes down.
Yeah. Well, of course, Big Pharma was the first one in with Marinol. If you don't know what Marinol is, that's a pill made by a big pharmaceutical company that is, I believe it's cannabis-based or synthetic cannabis-based. I don't know how you keep Big Pharma out, keep the right representatives in. I mean, they're allowed to compete as well. Education, like we hear from the Canna moms, about the dangers of pharmaceuticals, more so about the benefits of cannabis. And by passing laws to protect our physicians, because I have heard firsthand from physicians that they are still apprehensive about recommending cannabis because of the federal restriction that's still in place. They're not apprehensive about recommending FDA-approved pharmaceuticals because that's the norm in our country. So we have to look to the physicians as well to control that.